Let the video upload right quick. Okay, this is Trump and the G, and I'm Shock Exchange, and we've been giving you that heat. We've been giving you all the goings on with Fani Willis, the DA in Fulton County, Georgia, and the Trump racketeering case. The election interfering case against Trump and about 15, 16 other co-defendants. We gave you the importance of it before everybody else did. Now every blogger and every YouTube person every alternative media site wants to talk about Trump and the RICO case and Fani Willis, even before they knew the importance of it. But here's the latest update. This is from the article from the New York Post. It says Trump co-defendant claiming Fani Willis did not have authority to bring charges, given permission. He's been given permission to seek pretrial appeal. So Judge Scott McAfee is going to hear his pretrial appeal. And he's claiming an error of law here. It says, Fulton County Superior Court Judge Scott McAfee on Monday granted permission to Harrison Floyd to seek an appeal of a prior ruling in the Georgia 2020 election interference case. The former Black Voices for Trump director has unsuccessfully argued since last October that Fulton County DA Fani Willis lacked authority to investigate or bring election charges in the case because she did not obtain a referral from the state election board. And he's saying that she built her case on sand, and now the RICO case will be washed away. So here's the actual appeal from Harrison Floyd's attorneys in Georgia. He's represented by Harding Law Firm, LLC. And my understanding is that you can win a successful appeal if you point out an error of law in the court's decision. And how many election interference cases actually come forward in the United States? What happens? It's a 1 in 100-year event. So how many people actually know anything about it? If you think about it, seems like pretty arcane stuff. But this is what the appeal said. The defendant filed his plea bar on October 31st, 2023, asserting that Fulton County District Attorney did not have authority to investigation or presentment authority to bring election-related charges against the defendant absent a referral from the state election board. So they're saying that she couldn't bring charges unless she got authority from the state election board. So it's not just a legal issue, also a procedural issue as well. It is undisputed that no referral was sought or granted of the SEB. The state filed their response on November 23rd, asserting that they did not need a referral and that they had concurrent jurisdiction with the SEB. So this appeal seems like Fani Willis seems like she is the law. The law is whatever she says it is. That seems to be her response to Harrison Floyd's appeal, to Marjorie Taylor Greene, any criticisms from Jim Jordan, who chaired the House Ways and Means Committee. She seems to be the law, and it said, and this is consistent with her attitude. So the defendant filed his reply countering those claims on December 14, 2023. The district court denied the defendant's plea in bar in January. Then the defendant filed a certificate of immediate review on January 12th, or in the alternative to a motion to reconsider. So they're fighting. The court made a ruling, and they filed a motion to reconsider, which is, you don't want to prejudice yourself against the court, but they're not giving this issue up like a pit bull who won't cave in. So they must think they have a strong case. And the court denied the defendant's motion on March 14, 2024, and affirmed its January 2024 order, denying the defendant's plea in bar. So they're just going back and forth with the judge. As grounds for this motion, the defendant, Harrison Floyd, respectfully shows that a certificate of review is of such importance to the case that immediate review should be had in the Georgia appellate courts. Specifically, the immediate appeal will assist this court and the parties in determining applications of the mislisted Georgia statute. The issues presented in the defendant's plea in bar are issues of first impression in the context of election-related cases, and little case law is on point for guidance. So they're saying this is basically almost like almost breaking new ground. That's little to no case law on this particular matter, which makes sense because bringing an election interference case seems like a 1 in 100-year event. Seems like something, very arcane stuff. They go on to say that defendant Harrison Floyd asserts that the court erred in failing to recognize that this Georgia statute, OCGA 21-235, is a specific statute that overrides the general provisions of OGCA 15-12-100. To be sure, the Fulton County District Attorney does not have broad powers, but in an election-related case, those powers are clearly statutorily limited without a referral from the SEB. So I repeat, it says, to be sure, the Fulton County District Attorney does have broad powers, but in an election-related case, those powers are clearly statutorily limited without a referral from the SEB. Despite this court's explanation of harmony amongst these statutes to hold that the District Attorney holds concurrent jurisdiction with the SEB and that a referral from the SEB to the District Attorney is not necessary in election-related cases, renders OCGA 21-2-35 absolutely meaningless and superfluous. The Georgia legislature has provided concurrent jurisdiction 194 times in particular areas throughout the Georgia Code, yet no mention of concurrent jurisdiction is found with OCGA 21-2-35. So they're challenging the court's opinion, and there's no mention of concurrent jurisdiction pursuant to this Georgia statute. By allowing for concurrent jurisdiction within the Georgia Code that many times, if the Georgia legislature intended for a district attorney to have concurrent jurisdiction with the SEB, they know how to state such. By its omission, it is clear that the Georgia legislature did not intend for the district attorney to act unilaterally without the SEB's involvement. The text of the statute is clear that the Georgia legislature intended a referral from the SEB before a district attorney can take action on a case. Here, no referral was given to the district attorney. Therefore, the district attorney usurped the power given to the SEB by Georgia legislature to pursue her own agenda without any statutory authority to override the SEB. So they're challenging interpretation. Sometimes when courts make decisions, it can be interpreted, several different ways. They're saying the court's interpretation of this particular Georgia statute was the wrong interpretation, and that if the state wanted that interpretation brought by Judge McAfee, they would have stated as such. So they're saying it's clear, error of law, that District Attorney Fani Willis needed the SEB's referral before seeking this case. If that's the case, then it could be Mr. Harrison's ruling could be overturned on appeal. You can guarantee the other 16, 17 co-defendants are going to pile in on this decision, and they're going to ask for the RICO charges to be dropped due to a legal error by District Attorney Fani Willis. And it's something that seems kind of arcane, but still, this is what District Attorney Fani Willis is up against. These aren't regular people. Usually when a DA goes against a defendant, the state has the advantage. That's why that's why you're innocent until proven guilty. But these co-defendants, including Trump, they have a tremendous amount of resources, and they've got hundreds of lawyers looking at this case and trying to get these people off the hook and trying to get this case dismissed. They probably have volunteer lawyers who aren't even on payroll trying to get this case dismissed. So that's where we are. If this ruling is overturned on appeal, the case could be over. So that's where we stand. I don't think the media is really talking about it, but that's where we are. So this is Trump and the GE. Thank you for listening. Thank you.